What you're about to watch is one of the most surprising courtroom outcomes we've covered on this channel. This case centers around a chaotic medical emergency involving a mother struggling to breathe, an EMS team refusing to enter the home, and a son who desperately tries to help but ends up charged with obstruction. What makes this so compelling is how a few seconds of blurry, crowded footage ends up being dissected frame by frame in court. The prosecution insists the son grabbed an EMS worker with criminal negligence, while the defense argues it was nothing more than an instinctive, emotionally charged reaction during crisis. As you'll see, the judge takes this apart with precision, examining the law, intent, and what really qualifies as criminal behavior under Texas statutes. Stick with this one because the ending is not what the state expected.
Pressed upon him the need for perfection here.
This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over. And there's absolutely no excuse for the missed blows. How many missed blows do we have?
It says 19, Your Honor. That's seven, within that 7 or 8. But Judge, I would ask, if possible, as I'm not the lead on this case, and I know Dustin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So
I'm sorry, Ben, I can't. I have to know. You have to know that we mean business. I'm not here to toy with you and play games with you. Know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, y'all. Cold weather. I apologize. So can I please speak on the breathalyzer?
No.
Now pause for a moment here, because what the defense attorney is doing is crucial. He isn't just arguing emotions. He's arguing legal intent, which is the backbone of this case, for the state to sustain an obstruction charge against a civilian, especially during a medical emergency. They must show that the defendant intentionally interfered with EMS personnel performing their duties. But what do we see in the video? A cluster of bodies, frantic movements, and a son clearly fixated on his mother's worsening condition. The defense wants the court to see what's not visible, intent to cause harm or hinder care. And this is where trials get interesting. The difference between purposeful interference and panicked reflex can completely determine guilt or innocence. Let me know, if your parent were gasping for air, would your reactions be perfectly calm and mechanical?
No. You know what the expectation is. You have 19 missed tests. That's it. I'm sorry, Ben, I can't. You're here in his stead. You're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Please.
No.
But to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate, for alcohol.
I go to sleep early, man.
Test. And he is blowing outside the window, so we don't know what he's doing.
Oh my God, sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock one first thing in the morning, Your Honor.
Then you come here and you ask.
Oh, they just told me about this last week in pre-trial over there, and they said that I had a 45-day miss.
You have 19 missed blows, dude. Covering the camera.
Please, Honor. I will do anything. I'll even go on that drug, Anklemon. I'll do anything, Your Honor. I'm really trying here. I swear to God, I'll do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor.
The judge begins engaging directly with the defense's argument, and this is such an important pivot point. When the court starts asking questions about foreseeability and the officer's perspective, it signals that the judge is probing whether the alleged grab actually meets the legal definition of criminal negligence. Remember, criminal negligence requires a person to disregard a substantial and unjustifiable risk, a risk that any reasonable person would have known. But the defense highlights something powerful. The defendant's attention wasn't on EMS at all. It was on the stretcher, his mother, and the officers already making physical contact with him. without clear evidence that he knew his conduct put EMS at risk. The legal foundation starts to crumble. Moments like this show how critical precise language and mental state are in criminal law.
Please, Your Honor, it's just, I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock and I still did the ones later on when I would wake up. And they told me this just last week, Your Honor. I swear to God. I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one
I started
pass after the other. He goes with you. No.
Oh my God.
Your Honor, may we discuss setting a new bond further?
Of course.
Oh my gosh, Your Honor. Why? Please, I'm trying here. I'm trying to do everything.
Goes with you.
Oh my gosh.
Bond is at 5,001 now because of the prior violations. I will now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. He has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to view. It doesn't mean that there's.
It's the same thing. If we can't see you in the camera,
Yes,
then you're fooling. And I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, I've got it in black and white. And Dustin knows that it's no tolerance.
Consider 7502, Judge, for bond.
Okay, Ben. Okay, great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not gonna do that. I can't, but fine. Because, fine. All right, 7502.
She sent me an email from one of
If
the.
anything, have you done for your GED?
And what I did for it,
What have you done?
I went to a class and then I tried to go yesterday. They canceled it and he also,
You went the day before court.
and I also went before.
Judge, she's been going. She's been going before even the last court date, and we
Prove it.
I can text you.
In this life, you are only as good as the proof that you don't have. If you don't have proof, you have nothing. Spoken word means absolutely nothing.
Judge, the instructor, I had an email from him that she sent me saying that she's been going to the classes and that class was canceled on the 4th yesterday. But she did, attempt to go to class. So she's been going. She did already take a test, and this is the one where she did fail the first test. So she's been working on it. It's not enough.
I mean, here we are. How many resets have we had? We've had 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 resets since May. You're now in December. You have had 5 to 6 months. Show me the money. Otherwise, it's not going to go well for you today, Ms. Dixon. Show me. 5 to 6 months.
This is a pivotal moment where the prosecution reasserts its theory, claiming the defendant knowingly put EMS at risk. But here's the problem. The state's own witness already acknowledged that officers arrived after the commotion had started. That's a major evidentiary gap. If the police didn't observe the start of the event and EMS didn't provide testimony, then everything hinges on a video with a partially obstructed angle and frantic movements. The judge notes that those movements alone don't automatically equal negligence. The law requires a gross deviation, meaning the defendant's behavior must be outrageously careless by reasonable standards. But helping a struggling parent and reacting abruptly during panic isn't outrageous, it's human. And that's where the state's argument starts losing oxygen.
And Judge, this was a case where she was paying for the classes and then she had to then enroll into the free program, which she's been doing for the last little bit.
Are you playing Candy Crush? What's going on over there?
I'm trying to text you.
Texting who?
The instructor, like what I'm supposed to show you.
Listen carefully to how the defense frames the comparison between this case and a true criminal negligence case. By referencing the trailer scenario, where someone leaves a dangerous condition unaddressed for hours, resulting in death, the defense is reminding the court that negligence isn't about sudden emotional reactions. It's about conscious disregard. That comparison is brilliant because it shows how minor this incident is by legal standards. The judge immediately picks up on this, recognizing that the structure of negligence the state argues simply doesn't align with the defendant's actions. This is one of those courtroom moments where logic, precedent, and common sense strike the same conclusion.
Because I don't have no proof. Like I don't have nothing.
Tell me what have you done?
I went to the class.
Okay. Which class did you go
The
to?
GED resource.
Okay. And what, because the way I understand it, there are different modules that you do. You do science, you do language arts, you do math, you do, and whatever else it may be. You go through each section, you complete it, take a test, and then when you're done with everything, you take an overall test, and then you get a diploma.
That's not.
What have you done?
Basically explaining how everything's going to go, and I was going to finish everything else Wednesday when I was going to go, but the class was canceled.
Who is the provider that you have?
His name is.
Grab me a phone number because I'd like to call them right now. Yes, my name is David Fleischer. I'm a judge here in Harris County. And I have someone that's with me in our court, and she's doing a program with you guys to try to get a GED. I'd like to confirm that's Coriel Dixon. So Wednesday and Thursday, and then did you say every other Saturday? Okay. And then, so how does it work as far as getting the diploma? Do you do different classes as far as science, math, and how do you at the end get it? Can I put you, I have her in front of me. Can I put you on speakerphone so that she can hear this as well? Do you mind? Okay, hold on. So I've got him. Okay,
Hello?
Mr. Jackson?
Order in the court, please.
Okay, tell me, how goes it?
So, yeah, it's kind of twofold. They take an assessment. Based on that assessment, allows me to know where the student is as far as their grade level in math and in reading. Based on that, they go on 2 tracks. And so one track is like a probation education where we're just literally working on kind of some elementary reading and math skills.
Okay.
Or a GED track where they're ready for GED contests. And so, yeah, and I usually just, go from there. I work with my GED students individually. And
how long does the process take? And how long can we expect it?
Well, so that's honestly kind of a loaded question, depending on where they fall. I believe Coriel scored pretty well.
Great.
So yeah, and I've worked with people that have gotten the GED in 3 weeks. I've worked with people that have gotten the GED in 2 years.
Oh, yeah. I can't do 3 years. That's too much.
Well,
I know, I'm kidding.
No, I understand that.
She's
no,
been
but I mean,
faithfully attending though? Yay or nay?
yes,
Okay,
yes.
great.
And with some consistency, 3 to 4 months, maybe less.
That sounds great.
That's just me ballparking.
I'd like to stick with it because I think at the end of the game, our goal here is that she ends with that diploma. And I think that that would be a win for everybody. I'm basically, I'm calling you. I want to make sure that everything's going well, that she's attending, faithfully attending and doing well. And it sounds like you're saying that this is what's been happening.
Yes.
Great. Okay, so I'm just going to continue everything. Just continue to go, Miss Dixon. I mean, you got like what he's saying. If you continue at it 2 to 3 months, you'll end up with your diploma. Okay. All right. Thank you so much, Mr. Jackson. I really appreciate your help. You've been great.
No problem, Judge. You take
Okay.
care.
You too. Thank you, sir. Bye. Great. Good job. Just keep at it. Okay. So let's set it 30 days. I want to ride this through. You're so close to being through. All you got to do is see it to the end, and then everything great will happen for you here as well. Okay.
And there it is. The judge rules no probable cause. That means even at the lowest legal threshold, the state failed to demonstrate that a crime likely occurred. This is incredibly significant. Probable cause is far easier to establish than guilt, yet the evidence here simply didn't meet the standard. The judge outlines it clearly. The video lacked clarity, the defendant's intent wasn't shown, and the situation was a chaotic medical emergency rather than a criminal act. This case underscores an essential point. Not every tense or emotional moment is grounds for prosecution. Sometimes, people are simply scared and reacting out of instinct. If you appreciate breakdowns like this that highlight how the law really works in real-life crises, make sure to like the video, subscribe, and drop your thoughts below. I'm curious what you would have ruled if you were the judge.